Note one point on the issue of the maladministration point, with all due respect to my friend from California, whose time I'm now taking, and the ranking member, that in fact there were recognition at the time under Blackstone that maladministration was subsumed into high crimes and misdemeanors.
Well, I'll reclaim my time for just a moment to address that point. Blackstone is referring to English version of impeachment, which is radically different from the American version. Under the English version of the Parliament could impeach anybody they wanted, impose any sentence they wanted, including death. The American founders made it very clear that they had a very different model in mind. In fact, Hamilton made that clear in Federalist 65 and in Federalist 69, where he pointed out that once a president is impeached and removed from office, which was the limitation of the impeachment power, the judiciary could then prosecute him for the actual underlying crime.
Well, the gentleman from California, I read those exact passages as well, and note the difference with English law. But at the point at the time, there was no vote, there was no determination on that issue. But the point of my raising the issue now is that with respect to where we sit in this moment, we are left with making decisions as Congress on how to react to an executive branch not carrying out its law. So the fact is, as the gentleman from California raises, that in the gentleman from California's view, that it is pushing the envelope or extending into an area of defining high crime misdemeanor that the gentleman did not agree with, that the vast majority, obviously, of the Republicans and a majority of this body did.
Well,
because as a result,
reclaiming my time for just a moment, they did in this case. They took the opposite position to oppose the impeachments of President Trump. I would argue that both sides ought to be consistent, whether the shoe is on the Democratic foot or the Republican foot.
Right, and I would only point out, your point is, in here, we've got a redress that Congress is using, which the gentleman from California disagrees with using, because we are not answering the question which this effort by my friend from North Carolina is attempting to address.
I think
bring it back to the courts.
I think that the bill before us would add clarity to avoid that kind of discussion in the future. I yield back.
The gentleman yields back. We have the gentlelady from Georgia is recognized.
Thank you, Chairman. I'm truly in agreement with the argument that's being stated by my colleague, esteemed colleague from the state of Maryland, Mr. Ivey, and so I will yield the balance of my time to him.
I thank the gentlelady. Just quickly on the maladministration language, I thought, and by the way, I wish we had actually addressed these impeachment issues in judiciary. It was kind of ironic that it would just go through Homeland Security, but we'll leave that for another day. Maladministration was expressly rejected by Madison during the constitutional debate. That was recorded in the notes. And that's part of the reason that it should not be a standard used for impeachment now. But setting that to the side, back to this issue, I did want to continue to remind my colleagues about what Justice Kavanaugh wrote with respect to the issues of the separation of powers and with respect to the enforcement of these particular statutes. And I'll read this explicitly from his writing. In light of inevitable resource constraints and regularly changing public safety and public welfare needs, which are the ones I talked about previously, the executive branch must balance many factors when devising arrest and prosecution policies. That complicated balancing process, in turn, leaves courts without meaningful standards for assessing these policies. I'll skip the citations. Therefore, in both Article III cases and Administrative Procedure Act cases, this court has consistently recognized that federal courts are generally not the proper forum for resolving claims that the executive branch should make more arrests or bring more prosecutions. And then the court continues on to say, all of these considerations help explain why federal courts have not traditionally entertained lawsuits of this kind. By concluding that Texas and Louisiana lack standing here, we abide by and reinforce the proper role of the federal judiciary under Article III. And it goes on to address the state's novel arguments and that sort of thing.
Will the gentleman yield?
I will.
What do you make of the roadmap that Justice Kavanaugh offers in the majority opinion to how Congress can take action to ensure that the rule of law governs the executive?
Well, I think well, are you referring to the four-part test or the part that I read earlier?
The part that I read where he specifically said what Congress could do, confer legally recognizable, cognizable injury, and also empower the federal courts to provide remedies that would give redress.
I'll say two quick things. One is, I don't think your amendment addresses the four-part test that Justice Kavanaugh lays out in this opinion. And secondly, and more importantly, based on what I just read, it totally ignores the separation of powers issue based on the prosecutorial discretion standard, where the courts clearly and always give the executive the authority to exercise prosecutorial discretion. That's clear here.
Do you mean that
clear in federal courts as well with the Department of Justice and the like? I mean, it's just sort of standard fare, and that's what I just read. That's the point that Justice Kavanaugh just made.
Right, but both parts are in the opinion. Do you believe he didn't mean what he said when he told Congress how it could act to confer standing?
I believe what he said with respect to his recognition of the clear absence of resources to carry out the function that you all seem to think can happen by waving a magic wand, as opposed to providing the actual resources to do it. Namely, arrest and detain everybody, which is impossible, and that's what he just recognized. I just read that a few minutes ago. And then with respect to this, as Justice Kavanaugh points out, that's one of the main reasons that the type of determination you're trying to force the court into, via state attorney generals, by the way, and not even through at the federal level, but that's why Article 3, suggests that they should not be handling these kinds of cases. Somebody else over there mentioned, this is a legal question, not a political question, but I do want to note that the Supreme Court made a legal determination that this is a political question. That's the separation of powers piece, and that's why they don't want to take, get the courts in the middle of it. So, you're going to vote the way you're going to vote. I mean, I can see that's where we're going with this, but it's clearly in contrast to the argument that you're making, that you made with respect to the articles of impeachment, and it's in direct contrast to the United States v. Texas, which is why you're trying to essentially overturn it. And with that, I yield back.
Gentleman yields back. The chair now directs the gentleman from Arizona.
Thank you, Mr. Chairman. I just want to start by talking about the funding issue which has been raised. I heard that there was not enough money when they first started the catch and release programs again in late January of 2021. They had plenty of money. They could have detained, but chose not to. So let's get to this. I just want to raise a couple of issues. First of all, Kavanaugh didn't really address. He tried to distinguish, I think, the Massachusetts versus EPA case, but he didn't really do a convincing job. At least not for me. Certainly not for Gorsuch and not for Alito, but they didn't overturn that law. And that law says that states get special solicitude regarding standing. Special solicitude for standing is basically the recognition by the Supreme Court that there are cases where states should get standing when an ordinary person would not otherwise get standing. And so the reason I bring that up is that what's happening with this statute is consistent with what Kavanaugh said, but it also is consistent with Massachusetts, because we're trying to address here what is an injury, and what is the remedy, and should a state be allowed to raise that? And we're asserting that that's the case here. And that's consistent with Massachusetts, which is still good law. That's still good law. So, well, okay, yeah, it's still law. I'm not sure. When I say good law, that's a term of art, of course. It is good law. It is active law. And what that means then is that by us going in and saying this is the will of Congress, the courts are going to be more inclined, in my opinion, to say, well, under the doctrine of Massachusetts, then the states should have standing here. And the Congress has indicated its will. The state's trying to fill in and request relief. if they've iterated the damage. Now, I want to go further with that and talk about the confusion that the U.S. Supreme Court has given with regard to border security. I harken back to the U.S. versus Arizona case, where the federal government was trying to remove any capacity of the state of Arizona to defend itself from the onslaught that was coming on it at the time. And this is about 15 years ago. It was so bad that our then Governor Janet Napolitano wrote to the administration and said, we want $100 million because it's cost us that much just in incarceration costs. So with that in mind, the Supreme Court said that the field belongs solely to the federal government. If the federal government vacates the field, then the state can then enter the field. I continue to make the argument that the field has been vacated by the federal government. The states then can intercede. I think that this Texas case, Texas, Louisiana, trying to fill the field itself and being denied their relief on standing grounds. I think we have to go back and look at Massachusetts versus EPA, the special solicitude, and the fact that Kavanaugh himself gave us an avenue where Congress can weigh in and try to ameliorate standing concerns. I support the underlying bill, I support the ANS, and I oppose the Nadler amendment that we're considering right now. And if the gentleman from North Carolina, okay. With that,
I think maybe everything's been said, although maybe not everybody's yet said it, but it's just very straightforward. And I think telling that the objections were to, impeachment was a gross violation, so you can't vindicate the law that way, that is thought by the minority. And so if you go back to the case and you go back to the opinion that was supported by the liberal and conservative wings of the court with 6 justices, and they say, here's how Congress could fix this when in situations where it believes it appropriate to do so. That, look, the bottom line remains clear. They just don't want to fix open borders. That's all there is to it.
yeah, you'll bet.
Gentleman yields back. The chair recognizes, the gentlelady from Washington is recognized.
Thank you. I yield my time to Mr. Ivey.
Mr. Ivey, 15 minutes.
I can't let this bone go here. Yeah, and it's the SEC comment that really got, no, I apologize. All right. Look, with respect to, Congressman Biggs' comments, a couple of quick things. One is that the Supreme Court in this case, Texas, pointed out that immigration has a special status, as we all know, because it involves the executive branch dealing with, foreign policy issues, essentially. And, that's not addressed in the Massachusetts case you're relying on. And then also, I kind of wanted to mention, too, just Congressman Bishop's comment about our position. It's really not so much that we want open borders. I've been reading to you Justice Kavanaugh's opinion, which, you're saying you're relying on, and the articles of impeachment clearly referenced, although ironically, the articles of impeachment relied on Alito's dissent, and he was the lone dissenter. It was an 8-to-1 case. So you find yourself, standing against the other 8, essentially. The language you keep referencing with respect to supporting this amendment is clearly dicta. And it clearly also ignores the separation of powers issue that you haven't really discussed, which is, the resource piece that Justice Kavanaugh pointed out, and I guess I could read it to you again, although I don't know that it's, going to further the debate at this point. You've heard it already. He's already, he said for 27 years, through 5 presidents, they haven't had the resources to arrest and detain everybody. And that's undeniably true. There's no set of facts that were asserted in the case or by the Republicans here or during impeachment that suggest otherwise. You can't arrest and detain all of them. So therefore, the executive branch has prosecutorial discretion. It's their discretion to make decisions about where to draw those lines. And then Justice Kavanaugh explicitly connected the executive branch having that discretion with deference from the courts, including the Supreme Court, under Article 3 of the Constitution. I mean, it's, you know, I think pretty straightforward that what you're trying to do here flies directly into the teeth of that. And it's a frontal assault on the United States v. Texas, which you got the right to do, I guess, but to then say that this opinion supports what you're doing in essentially trying to overthrow what Kavanaugh wrote, I think is hard to support. I'll say it that way. And with that, I'll yield back to Ms. Jayapal.
Would the gentlelady yield for a question?